Welcome to this webinar presented by the It's My Choice project from the Barbara Schleifer Commemorative Clinic. The It's My Choice project is funded by the Department of Justice Canada. This webinar is one in a series that gives basic information about areas of law that may be helpful for survivors of gender-based violence. This webinar will focus on humanitarian and compassionate applications. The information in this webinar is current as of February 13th, 2026. Please note that this webinar is designed to provide legal information and does not give legal advice about any specific situations. If you or someone you know has specific legal questions, it is best to consult with a lawyer. If you need help finding a lawyer, you can contact your local legal aid clinic or the Barbara Schleifer Commemorative Clinic. Let's begin the webinar. A humanitarian and compassionate application, also known as an H&C application, is a request made by an individual who does not necessarily meet the regular requirements for permanent residence, but wishes to remain in Canada due to exceptional circumstances. H&C applications are meant for individuals in Canada who have compelling reasons, also known as humanitarian and compassionate grounds, to remain in Canada, despite not qualifying for permanent residence through any of the standard immigration pathways. For this reason, they need to request an exemption from one or more requirements of Canada's immigration laws or rules. H&C applications can serve as a pathway to permanent residence in Canada for survivors of gender-based violence. Before we discuss the details of H&C applications, it is important to understand who the decision makers are. Immigration, Refugees, and Citizenship Canada, also called IRCC, is broadly responsible for setting immigration and refugee policy for the Government of Canada. On an individual scale, however, IRCC is also responsible for making decisions on various immigration applications, including H&C applications. H&C applications are essentially paper applications. This means the applicant is solely responsible for presenting all documentary evidence and relevant information about their circumstances to IRCC. The applicant is rarely interviewed by the IRCC officer deciding their H&C application. This means their case will be decided based on the paper record before the IRCC officer. H&C applications are also highly discretionary applications. That means they are decided on a case-by-case basis and consider the applicant's unique personal circumstances. IRCC officers review the person's overall situation and decide whether humanitarian and compassionate factors justify granting an exemption from standard immigration rules. IRCC officers can refuse or approve H&C applications for a wide range of reasons. Some individuals are not eligible to make an H&C application. First, you are not eligible if you have an active refugee claim before the Refugee Protection Division or an active refugee appeal before the Refugee Appeal Division of the Immigration and Refugee Board. This also applies if you are judicially reviewing a negative refugee decision. There is also a one-year bar. This means if you had your refugee claim or appeal refused, withdrawn, or abandoned within the past 12 months, you would generally not be able to make an H&C application unless you qualify under one of the two exceptions. You may be exempt from the one-year bar if there are best interests of the child considerations. You may also be exempt if you or your dependent would not be able to receive life-saving medical care if forced to return to your country of citizenship. If you have made a refugee claim that was determined ineligible to be referred to the Refugee Protection Division, and you have subsequently applied for a pre-removal risk assessment application, which is pending, you may not be eligible to submit an H&C application. Individuals who are inadmissible to Canada for reasons such as being a danger to Canada's security, being involved in terrorism, espionage, or organized crime or being suspected of serious human rights violations are also not eligible to submit an agency application. Finally, if the Minister of Public Safety and Emergency Preparedness has determined you are a designated foreign national within the last 5 years, you may also not be eligible. This is an overview of the general eligibility rules, but eligibility to apply for an agency application can be quite complex depending on the unique circumstances of your case. It is best to consult a lawyer if you have any concerns about your eligibility to apply. Agency applications involve 2 stages. At the first stage, IRCC will assess the humanitarian and compassionate factors in your case. An IRCC officer will decide if these factors are compelling enough to grant approval in principle. This means that the applicant has been approved to apply for permanent resident status in second stage processing. At the second stage, IRCC will assess whether the applicant is admissible by completing background criminal, security, medical, and financial self-sufficiency checks. An applicant's family members may also be screened, whether they are included in the application as accompanying dependents or not. An applicant who is approved at the first stage can still be refused at the second stage if they do not pass those background checks. It is important to remember that although an agency application is filed with IRCC and a decision is pending, there is still a chance that the applicant can be removed from Canada. This can be the case when the applicant does not have legal status in Canada. An agency application does not stay removal. This means that having an agency application in process with IRCC does not prevent, delay, or pause deportation from Canada. If an enforceable removal order has been issued against you, you could be removed from Canada even if you submit an agency application, or even if you are awaiting a decision from IRCC on your agency application. If you have been given a removal date or have been called in by Canada Border Services Agency or CBSA to make removal arrangements, speak to your lawyer about ways to postpone your removal from Canada, such as a stay of removal before the federal court. While having an agency application in process with IRCC does not automatically stop or delay your removal from Canada, it can form part of a legal argument as to why a stay or a pause on removal should be granted. For applicants who are out of status, there is a risk that filing an agency application will alert CBSA, the government's immigration enforcement agency, to the applicant's presence or address in Canada. In the clinic's experience, however, IRCC does not generally request that CBSA enforce removal proceedings against agency applicants without status, unless the applicant has an outstanding immigration warrant or other serious allegations against them. If an applicant is removed while their agency application is in process, the agency application will continue processing. If there is a positive decision, the applicant is provided with a visa allowing them to return to Canada. However, additional permissions from IRCC to return may be required. It is important to know that agency approvals after a removal from Canada are very rare. Finally, if you receive Stage 1 approval, which is called approval in principle, a regulatory stay of removal will apply. This means that you are allowed to remain in Canada even if you are out of status, while a decision on your agency application is made at the second stage. In terms of the actual agency application, there are 3 main elements that an IRCC officer focuses on when making a decision on whether to grant the application. First, what is the extent of an applicant's establishment in Canada? Second, would it be in the best interests of any minor children involved in the applicant's life if the applicant were to return to their country of citizenship? And third, will the applicant and any dependents included in the application face hardship if removed from Canada and returned to their country of citizenship? It is very important for an applicant to show that they and their dependents have become well established in Canada. A significant degree of establishment can include long duration of the applicant's stay in Canada, connections to friends and family in Canada, any education, schooling, or training in Canada, any employment or volunteer work in Canada, ownership of property, savings, or assets in Canada, ability to speak fluent English or French, evidence of participation in community events, or membership in organizations. One of the main issues in terms of showing establishment that the clinic's clients face is the issue of financial inadmissibility. It is important to be aware that an applicant's H&C application can be refused at Stage 2 processing if the IRCC officer thinks the applicant is unable or unwilling to support either themselves or any dependents financially, or they have relied on social assistance and continue to do so. For example, a woman who has been isolated by her abuser may find herself in a precarious financial situation. However, the H&C scheme allows for an exemption to financial inadmissibility. So if this is a concern, speak to your lawyer about how your financial situation impacts your H&C application. Second, IRCC is required to consider the best interests of any child under the age of 18 that is directly affected by the decision. Any child directly affected in this context can include the applicant's own child, no matter where the child was born or where they live, whether in Canada or elsewhere, a child in Canada who is not the applicant's child, but with whom they have a close relationship. For example, this could be a friend's child that the applicant looks after, or a child outside Canada who is not the applicant's child, but who relies on their support in some way. For example, this could be a niece or nephew abroad that the applicant financially supports. Some factors that IRCC considers when determining the best interests of directly affected children are the child's age, the level of dependency between the child and the applicant, the degree of the child's establishment in Canada, separation between the child and any parent or close relative in Canada, the child's links to the country in relation to which the H&C assessment is being considered, conditions in the applicant's home country and the potential impact on the child, medical issues or special needs the child may have, impact to the child's education, or matters related to the child's gender. It is important to note that although the core best interests of the child analysis focuses on children under 18 years old, the situation of children over age 18 can still support an applicant's H&C application. Lastly, IRCC will analyze hardship. Hardship is a subjective analysis and looks at whether the applicants or their dependents would experience hardship if removed from Canada and returned to their country of citizenship. Hardship could involve anything that would cause the applicant or their dependents to be emotionally, psychologically, socially, financially, physically, or otherwise harmed. The test for hardship in an H&C application is notably less stringent than the requirements to show persecution for a refugee claim or a pre-removal risk assessment application. While hardship is different than persecution, it is important to inform your lawyer of all the reasons it would be difficult for you to return to your home country. Some factors that can establish hardship include returning to an abusive relationship or other family violence considerations, lack of access to suitable health care, including for mental health, lack of ties to the home country, lack of family and community support in the home country, possibility of experiencing discrimination or other human rights violations, laws, practices, or customs that might put the applicant at risk of abuse or social stigma, poverty or generally difficult economic conditions, political unrest, war, instability, or widespread violence, and natural disasters. There are a few other considerations to be aware of when submitting an H&C application. Currently, IRCC's processing time for H&C applications is more than 10 years. This is important to consider because if you are out of status in Canada, you should seek legal advice about your status while your H&C application is processing. IRCC will expedite the processing of H&C applications in family violence situations. However, they do not publish how fast they expedite these types of applications. It may still take several years to receive a decision. H&C application processing fees may also be a consideration. Presently, H&C applications cost 635 Canadian dollars for each adult and 175 Canadian dollars for each dependent child. If your H&C application is approved, each adult will also need to pay an additional right of permanent residence fee, which is presently 575 Canadian dollars. Please note that IRCC periodically increases its fees. Finally, although multiple H&C applications can be submitted, repeated applications without any significant change in circumstances are not likely to succeed. To conclude, while H&C applications can often be the only way for individuals without legal status in Canada to obtain permanent residence, it is important to consult with your lawyer about your individual circumstances. The Barbara Schleifer Commemorative Clinic offers legal, counseling, and interpretation services to marginalized and racialized populations of women and gender-diverse people who have survived violence. The It's My Choice project aims to increase access to justice by providing fully integrated, trauma-informed, independent legal advice and independent legal representation to women and gender-diverse people who have experienced sexual assault and/or intimate partner violence. For sexual assault survivors, this includes criminal and non-criminal options. For survivors of intimate partner violence, this includes family law, immigration law, and intersections with criminal law. Furthermore, in partnership with community organizations across the province, sexual assault and intimate partner violence survivors will have the option to access these services remotely at satellite or pop-up clinics and on-site at the Schleifer Clinic. Thank you for watching this presentation from the It's My Choice project at the Barbara Schleifer Commemorative Clinic. Please note that the information in this webinar is current as of February 13th, 2026. Immigration laws, policies, and requirements may have changed following the recording date of this webinar. If you have questions or would like to talk to a lawyer, you can contact the Barbara Schleifer Commemorative Clinic at our website or 416-323-9149. Thank you.